Morning, everyone. It's a pleasure to welcome you all to today's panel discussions on the first few months of DMA, the DMCC, and the future enforcement in digital markets, organized by Comppit, the Research Center for Competition, Public Policy, Innovation, and Technology of FGV Law School, with the support of IBRAC, the Brazilian Institute of Studies on Competition, Consumer Affairs, and International Trade. This is a topic of immense importance as we navigate the evolving regulatory landscape of digital markets, the Digital Markets Act in Europe, and the Digital Markets Competition and Consumer Bureau, the DMCC in the United Kingdom, represent significant strides in addressing the challenges posed by the digital economy. These regulatory frameworks aim to ensure fair competition, protecting consumer rights, and foster innovation in an increasingly digital world. As we assess the early implementation of these regulations, we find ourselves at a critical moment, examining both the achievements and the hurdles encountered so far. The DMA, which came into effect a few months ago, seeks to curb the dominance of large digital platforms and ensure a level playing field for all market participants. It introduced a set of obligations and prohibitions for gatekeepers designed to prevent unfair practices and promote competitive markets. Initial feedback from stakeholders has highlighted both the positive impacts and the challenges in enforcement. On the one hand, there is certain optimism, so to say, among smaller market players and consumers. On the other hand, questions about the practicality of some requirements and the resources needed for effective enforcement are emerging. Similarly, the very recent DMCC bill in the UK aims to enhance the regulatory framework to better address the complexities of the digital economy. The early reactions to this bill reflect a mix of support and concern, emphasizing the need for careful consideration in its implementation to ensure it meets its intended goals without stifling innovation. It's important to note that the relevance of the discussion extends far beyond Europe and UK. Here in Brazil, we are closely observing these developments as they offer valuable lessons and insights for our regulatory environment. The experiences of Europe and UK can provide us with important benchmarks and best practices as we navigate our own regulatory and challenges opportunities. In this context, it's worth mentioning the recent public consultation opened by the Brazilian Ministry of Finance, Department of Economic Reform, in January this year. The consultation period ended on May the 2nd, and the IBRAC has participated in the public consultation and is also promoting the discussion of this hot and important topic in different seminars and webinars within the recent months and years. Today, we have the privilege to hear from Professor Ioannis Kokkoris, who will share his insight and experience regarding these regulatory frameworks. Professor Kokkoris is a professor of competition law and economics and director of the Center for Commercial Law Studies at Queen Mary, University of London. After his presentation, we will have comments from Silvia Faga de Almeida, Vice President of IBRAC and Director at LCA, Consultoria Econômica, and Marcela Matiuso, Partner at VMCA and Coordinator of Digital Markets at IBRAC. Our discussions will be moderated by Professor Caio Mário Pereirato from Comppit and Professor at FGV Direito São Paulo. Thank you all for being here. Thank you, Caio, for organizing this event and inviting us to participate in this very interesting discussion.
Obrigado. Bom dia a todos e todas. I'll also shift to English here in benefit of our guest, Ioannis Kokkoris. Thank you, Ricardo, for the great introduction, and welcome you all to this event organized by Comppit at FGV and with the support of IBRAC. It's always a pleasure to partner with IBRAC in events as well. Before we start, just a quick disclaimer because we're recording this session. So the manifestation is expressed by members of the staff of the Getúlio Vargas Foundation, by guests who participate in events and control them. Online represent exclusively the opinions of their authors and not necessarily the institutional position of FGV. We also reiterate that everyone present here has agreed to participate in this event spontaneously, and with that, authorize the use of the name, voice, and image, in addition to assign copyrights related to the exposure for this transmission that later remain on the official channels of FGV. To continue this transmission, we ask you to express the agreement, verbalizing or signaling your agreement. Thank you very much for agreeing with this. Professor Ioannis Kokkoris from Queen Mary University is a very good friend and has been here before, participating in other discussions with us at FGV. So it's always a pleasure to have you back when you come to visit the country and to give us some news about what's happening in the UK and in Europe. So thank you so much for being here with us. And he's not only a professor at Queen Mary and the director of CCLS, the Center of Commercial Law, but also is recently appointed to the CAT, the Competition Appeals Tribunal at the UK, where they hear appeals against the CMA, but also the other regulators there. So extremely interesting position as a judge now as well, Ioannis. So congratulations on the recent appointment. And today I think he's here to talk about a very timely topic, as Ricardo mentioned. So both on the first month of the DMA, which is now in a crucial moment of enforcement, with the first infringement procedures being brought and the discussions coming up in Europe about the enforcement of the Digital Markets Act. But also, and even more timely, the DMCC was approved on May 23rd, so 2 weeks ago. And it's probably the most encompassing and the broadest initiative so far to deal with ex-ante regulation of digital markets. So it's going to be great to hear from you on these recent developments and what to expect on the DMCC enforcement as well, Ioannis. So without further ado, I'd like to give you the floor and thank you so much for coming. He just arrived this morning, so it's a great pleasure to come directly to our talk.
Can you hear me like this, or do I need the mic? So thank you, Director FGV Caio, to Ricardo for the invitation to come. It's a pleasure to be back and be with you. The views are strictly personal. I'm told I have to reiterate every time I now speak in public fora, so personal views to me reflect any institution, especially the country. What I will try to talk about briefly is what we have seen so far from DMA, what happened with DMCC, and how is the ground laying out for DMCC now in the UK and lawsuits against big tech companies in the UK. Caio mentioned that the DMCC got final approval a couple of weeks ago. We have elections in 4 weeks from now, so that was one of the last bills or the last legislative initiatives that we were hoping would go through and will not be frozen because of the election, and we would have to wait probably another year. Already DMCC has been delayed at least twice, so we should have had the DMCC before, a few months before Boris Johnson resigned. So that goes back now a couple of years. Then we were having DMCC again a few months later when Liz Truss resigned. So now finally we have the law. So now that we have the law, it gives, and I will go to the FCC, but finally CMA has the powers it always wanted to have, It wanted for a number of years now. It was setting up the internal machine to be able to enforce the FCC, but didn't have the law yet in place. So now they do have the law. But we get to the FCC. Let me start with the DMA very briefly. Most of you...
Yes. This one, just further here, camera would be...
Okay, yes. Shall I try to stay here so I don't actually...
Yes, I think that's perfect, or even in the front here, even better, yeah.
Okay,
yes.
Thank you. So I think all of you or most of you would know about the DMA objectives and what they are about. DMA came into force aiming to address the challenges the Commission was facing in contacts in digital markets. The Commission was trying to address this through unilateral contact cases. Some of them were successful, some of them were not, some of them were taking too long. So it came up with DMA to try to actually improve the market behavior in digital markets. It goes back to TFU. I don't want to go back to the background on DMA. It's already now done. That's just for setting the scene. What the Commission wants to do with the DMA is to ensure that it can act faster and more effectively on contacts that it sees as affecting markets, but may not have always the right type of toolkit to address them in full. So, for example, we see DMA bringing in and emphasizing the concept of fairness, because fairness as a concept is quite wide. What is fair, what is unfair is not always the same as what is competitive and what is anti-competitive. So bringing in the fairness concept, and to be fair, what that reminds me is Vestager, when the Google search decision came out, was talking a lot about fairness. So this type of fairness concept started not as a result of DMA, started before DMA with the first big case against the big tech, because the Commission was feeling they need to think outside the constraints of unilateral contact abuse of dominance and what these precedents of abuse of dominance actually would impose on the Commission to do. So it started to actually focus on concepts of fairness. Fairness as a concept is very broad. Commission likes broadness in this respect. I think any authority would like broadness in this respect, because it allows the authority to cultivate that concept and apply that concept as it deems fit in the context it has in front of it. We have now gatekeepers. Interestingly, when the gatekeepers were announced, which are the companies that the DMA will apply to, majority of them, of the companies, accepted the fact that they're a gatekeeper. We had a couple who pushed back, but the majority of them actually accepted they're a gatekeeper. And we have the current list of services, because not everything a gatekeeper does is subject to DMA. We have the current list of services, and this list is a live process, actually a living process. This list will be updated and will keep being updated. As more services or companies fall and meet the thresholds, they will go to the list. If some of these companies get below the thresholds, they will be removed from the list. And since 6 months, since 6th of March, these companies now need to abide by DMA. This Commission gave a 6 months grace period. September was the clarification or the announcement of gatekeepers. 6 months the Commission gave to gatekeepers to actually put their act together to try to address any contacts they feel is subject to DMA and would fall foul of DMA. If we correlate some of the decisions, the ongoing cases from summer 2023 until now, Apple being one of them, for example, the type of commitments Apple decided to give for one of the cases in relation to the app stores, in effect, is very similar to what Apple will have to do under the DMA. So we saw already certain companies which were already investigated by the Commission, the investigations for some of them are still ongoing, to try to address some of the concerns on the cases that were ongoing by trying to introduce measures that would comply with DMA. So we started to see some of the positive impact of DMA, if you wish, on the behavior of companies. It's a common, I don't know if it's a common joke or a common knowledge now in Brussels, that the moment that DMA was passed, there were law firms waiting to push the button on suing big tech. So I've been in different events and I come across law firms that I've never personally heard before in my life. Very small boutique law firms. They don't do competition, they do litigation. But now they have been collaborating with competition boutiques just to do litigation. I will not say just on big tech, but big tech is a main part of the market. So there are a number of complaints. We heard there were many complaints. The moment DMA comes into play, we push the button. And we started to actually see that. Started to see complaints coming in against the gatekeepers. And the Commission has taken action against Google, Apple, and Meta. So already the Commission, to go back 1 second, the Commission has the power to start the actions in March 24, and the Commission already started these actions. So these actions were being prepared before March 24, because there were complainants who were arguing that companies will not actually abide by DMA. The Commission has been really open in this. So there were compliance workshops where Commission invited stakeholders to share their views on whether they feel gatekeepers are fully abiding by DMA. And in these workshops, additional concerns were identified. We do not know which ones, and if at all, some of them were also the base for some of the investigations, but it would not be unlikely to consider that can be the case, that some of them would strengthen the Commission's view that some of the parties, some of the companies, some of the gatekeepers are not actually fully abiding by their obligations. And if you have read DMA, and I'm sure most of you have read DMA, it's not a very easy text to read and understand. So you really need to have technical knowledge in addition to a legal or economic knowledge to be able to understand some of the clauses there. And this is because there's a piece of legislation which is trying to address a very highly complicated market and how a market operates. The workshops gave the Commission the opportunity to understand a bit more some of the concerns, gave the complainant the opportunity to air them. So strategically, it was a good move of the Commission to be open to this type of workshops to understand exactly whether there are still concerns remaining in the markets. Now, the cases we have, some of the initial cases we have against Apple, and that's subject to Article 5.4 of the DMA. Apple seems to restrict possibilities of business users to advertise offers to end users. So there seems to be a complaint. There is a complaint in relation to that. So Commission is investigating that. Is investigating further violations that Apple puts from switching to other offers. That's Article 6.3. We have a similar article of DMA 5 for the same article of DMA 5 for similar conduct against Google that CMA is investigating. The European Commission is investigating. And we also have self-preferencing. I don't know, when I was trying to put an address on Google Maps in UK, in the past, I could put the postcode, I would come up with a clickable map. The clickable map had disappeared. So in the past, you would get, that was self-preferencing in the past. You would get the clickable map, you would click on the map, you would go to wherever you want to go on the Google search page. The map is there now, but you can't click anymore. So I had a colleague of mine in a similar event like this was asking the question, he's in the consumer law area. So he was asking the question, as a consumer, it was easier for me to go on Google.com, put a postcode, click on the map and go where I want to go, than putting now I have to go to Google Maps, put the postcode on Google Maps to be able to find out where I want to go. So there was an interesting consumer perspective of one individual only, implying that, okay, this seems, what Google is doing seems to address possibly part of what self-preferencing was about, but at least in his opinion, he has a worse experience. Now, I'm not suggesting that this is the way necessarily that the authority should see it, because to start with, it's one user, and the whole point of self-preferencing conduct or a clause against self-preferencing is to be able for the market to allow more competitors in this type of services to arise. But it's interesting how consumers see the outcome of some of these changes. And this we will not know soon. We need to actually see the outcome and then see how consumers feel about it. And so there's a one on self-preferencing against Google. Google has taken steps, the one I was discussing, but what came out from these workshops and possibly other documents the Commission has seen, the Commission is not certain whether the Google's changes are sufficient to be fully in accordance with DMA, so it's still an ongoing investigation. Meta, pay your consent model, so you either agree to link your personal data or you have to pay a fee. That's not exactly what DMA had in mind. You have to pay a fee or you can use the data, in my own reading. So when DMA says you have to provide an equivalent less personalized alternative, it doesn't mean pay. It means you have to do your best efforts to provide such an alternative. And the question is, have you done these efforts to provide such an alternative? And if you have done and failed, why? So ongoing investigation against Meta as well. I have here a statement by Commissioner Brenton in relation to DMA requiring companies to provide end users with a free version of the services, which means, according to what Commissioner Brenton said, what Meta's way forward is still is not in accordance with DMA. All of these investigations currently ongoing. One question I have in my head is, when are they going to finish? Because if you would expect, and I would hope, they will be done in an expedient manner, because that was one of the main benefits of having DMA. We'll see how long they will take to finish. I'm sure the companies are putting in a lot of responses that need to be addressed in detail, but it will be interesting to see the first few cases, how long they take, what results they have, if there are remedies, what kind of remedies are there, and to see the first, I will call it in inverted commas, successful enforcement cases of DMA. Successful, not in the sense of necessarily penalizing the companies, is assessing a case, assessing a conduct, coming to conclusion. Yes, there's a harm or there is no harm, but do it in a way that it will be similar to what the EC had in mind when it established the DMA. We will see many more cases. I think what we see now is a case which was being prepared before DMA came into full effect, before March. If we end up having with the resolution of investigations, that will be a very positive outcome of the new regime, and one that the existing regime of unilateral conduct could not achieve. So that would be a big plus for the new regime. And we'll see how quick these conclusions can be. But so far, if we compare the world of these services a year ago and today, maybe a year and a half ago and today, personally, I have seen changes that I think are in accordance with the parties having to abide now by DMA. Is it enough? I do not know. Have they done what it takes? I do not know. That's what the Commission is assessing. But it seems what DMA is doing has started to have an impact. The fact that my colleague does not like that they have to click on the map and the click doesn't work, doesn't mean that this remedy, let's call it remedy or commitment, is not appropriate from a competition point of view. So what I would not like to see is DMA case is becoming another Google or Microsoft case, going on for years, having a remedy which doesn't work, and then the whole market changes between beginning and the end. Happy to take thoughts now or continue with DMCC. contingency. So this is more exciting in some ways, but this is even newer than DMA. CMA already had the people in-house to be able to want to apply. DMCC didn't have the bill. EC had the bill that didn't have all the people in-house. So UK is really ready to actually apply DMCC. And I will go also, and I will talk also about cases which are actually before the courts now in the UK in relation to big tech. DMCC is not DMA. Sorry, DMCC is not just DMA. DMCC is DMA and DSA together, and also has other add-on elements there, because DMA is its market structure, focus. DSA is how users are being perceived and how users may be treated online, but not from a competition angle. DMCC covers both angles. So, for example, DMCC will cover aspects of conduct of strategic market status of companies which have strategic market status, gatekeepers in the DMA jargon. But it also has conducts which affect consumers from a consumer law perspective. So if there is misleading information on a website, that can be subject to DMCC. If there is a possibility that in an election period, certain services of the strategic market status companies affect public opinion, and this information may be inaccurate, that's not DMA, that would be DSA, that's DMCC here for the UK. So DMCC is wider. Contrary to DMA, also covers merger control. Sorry, I'm moving back and forth in the script, I'm sorry. Also covers merger control. DMA, the DMA statement of merger control is you have to notify a transaction if you are a gatekeeper. But this is as far as it goes. DMCC is more prescriptive on merger control. So it has new harbors, new safe harbors for merger control, new thresholds for merger control, for mergers of these companies, for mergers involving these companies. So the whole clear acquisition of which we've been discussing in competition world the last 5-6 years, DMA doesn't cover it explicitly. DMA says you have to notify, and then I'm going to actually assess, and I'll assess, of course, if it's clear acquisition or not. DMCC explicitly tries to address transactions which could be clear acquisitions. So DMCC is more prescriptive on mergers. That's one difference. The other difference between DMCC and DMA is the consumer versus competition angle. That DMCC covers both angles. I have here some of the main clauses just to show the parallelism with DMA. So clause 23 of DMCC, which provides the anti-competitive conducts. If we look at these conducts, self-preferencing is in DMA, discriminatory terms is in DMA. It's also in chapter 2, article 102. Fair enough. Yes, I agree. Leveraging market power, DMA and chapter 2 or article 102 equivalent. Tying undertakings, distinct interoperability, using data unfairly. So very, very similar to the DMA conducts. And we wouldn't expect something different, to be honest. We wouldn't expect UK coming up with a different set of conducts that would be different to what DMA covers. Maybe there would be some differences, maybe there would be some more specialization in some particular conducts, but broadly, they cover the same aspects when we talk about the competition side of things. Now, we have in the CMA, we have the digital markets unit, which currently they're looking for a director for digital markets, by the way, from in CMA. So they're trying to actually beef up that unit. A large majority of DMU decisions will be subject to judicial review. That's interesting. In the UK, you have the full merit appeal or the full merits appeal or appeal of a judicial review standard. For example, cartels, unilateral conduct is a full merits appeal. So the Competition Appeal Tribunal can go in, can look at the substance of the case, can look at the conduct, can look at what happened and whether they agree or disagree with the CMA. Mergers, the Competition Appeal Tribunal cannot do that, as mergers are appealed on the basis of a judicial review standard, which is the decision proportionate, is the decision one that the rational authority will take, and it does not have by nature the same in-depth substantive analysis at appeal stage that a cartel or an absurd dominance would have. So there was a lot of back and forth whether DMU decisions will be full merits or judicial review standard. And it was decided that DMU decisions will be judicial review grounds. If it's a penalty decision, then it can be reviewed on the merits. But if it's a conduct decision, it will be based on a JR standard. Views vary whether JR standard is less or more strict than a full merits standard. And you may form your own view about which one is stricter. DMCC uses necessity, not indispensability, for the countervailing benefits exemption. So when DMA has a type of inefficiency defense, we use merger jargon, or a 1013 type defense, bringing efficiencies, that is not mirrored in DMCC. DMCC uses the concept of necessity, that the benefits have to be necessary in order to be taken into account to outweigh harm to consumers. And depending on how we read it, one may argue that the DMCC sets a lower threshold by the wording that it uses, that this type of benefits could not be realized otherwise. So you need the conduct which in principle is anti-competitive, because otherwise the benefits could not be realized. Conduct requirements by the CMA have to be proportionate. Again, a lot of back and forth between Commons and House of Lords. House of Commons, the House of Commons, and the House of Lords are the two bodies that review the legislative document back and forth until we have a final bill which goes for royal assent. So that's part of the legislative process. DMU can impose conduct requirements if they are proportionate to the objective. And again, we have an appropriateness standard introduced. Interestingly, what the DMCC does also introduces a market investigation-like type process. So it allows CMA to introduce remedies where there is clear evidence of harm of competition, and rather than, it's not a particular conduct of a particular company that is doing something wrong which has this harm, is the way the market structure creates harm to competition. Under a market investigation approach, you would go in, you would assess it, you would go to a market study, you would do a market investigation, and then you would come up 2 or 3 years later with remedies on how you will improve the market. In past market investigation cases, remedies would be, for example, you have to divest assets, or you have to have some behavioral commitments. Here, the DMCC introduces a similar type of assessment and intervention, but in a faster time frame. So if there are market structure issues that the CMA feels affect the way that certain aspects of digital markets are operating, they can do a similar type of assessment, not against the company. It's not against the company, but the remedy can be against the company. The difference between this and a case as such is if you have a case against a company, then you have damages against that company, possibly. If you address a harm based on a market investigation process, the company itself has not done something wrong. So there is less room for a damages case there. Next steps, consultation of the new guidance. The CMA followed EC on this approach, consultation on the new guidance. October, the DMCC Act will come into force. DMU will actually finally assume its powers. There's a timeline, as you see. There's a timeline on when the DMCC will come into effect and DMU take full effect. When we will have the SMS designations, strategic market status designations, the gatekeepers equivalent for DMA. CMA expects 3 to 4 investigations in the first year. I'm sure it's not just out of its head. I'm sure it has received information that makes it confident it can have 3 to 4 investigations in the first year. And what would be interesting to see is if we see the same type of change in the behavior of companies before DMA came into effect, whether we will see a similar approach in the UK before DMCC comes to effect. And final slide is that there's a whole parallel universe of damages cases against big tech. I was counting them on Monday, 8 ongoing cases for damages against Google, 5 against Apple, 1 against Meta, 2 against Amazon. Some of these claims are really large. I would say half of these claims are in the UK. We have the opt-out regime is equivalent to a class action in the US, which means the amount of damages is quite significant. There is a growing market, an increasingly growing market for litigation funding in Europe. So we will see more and more of these cases everywhere in Europe, not just in UK necessarily. And we'll see. We'll see how these cases proceed at the CAP. Thank you. Obrigado. Did I take half an hour?
Yes, but that's good. That's perfect, actually.
I would have swore I got 20 minutes.
That is perfect. Thank you so much, Ioannis.
I'm very slow.
Okay, so let's get back to our table here, or improvised table, actually. Thank you so much, Ioannis, for the talk. I think lots of food for thought here. And I'd like to pass on the floor to our commentators. So maybe we could start with Marcela and then Sylvia. Of course, I think there's lots going on, and there's also lots going on in Brazil as well. So I'd like to hear from you and start this conversation with Professor Ioannis, and then we're also going to open the floor to the audience so that we can have a broader conversation as well. So please, Marcela, I'd like to start.
So thank you all for being here. Thank you, Professor Ioannis, for the very instructive overview of the DMA and the DMCC. I have like loads of questions, but trying to think of this discussion as it relates to Brazil more specifically, but other jurisdictions in general. I think one of the main questions that we have is whether like the impact of the enforcement of the DMA will like cross over to other jurisdictions, right? So how the companies are implementing the remedies over there, will it or will it not impact other jurisdictions? And I think it's interesting to see that, as you mentioned, like in the Apple case that you brought up, like this is already happening sort of like within Europe, like within the European Union. So there is a competition case, and some of the remedies that the company is willing to provide are actually things that they have to comply nonetheless because it's in the DMA. And we have one example in Brazil that might be interesting for that. So we also have an App Store case against Apple in Brazil. And CADE, the Brazilian Competition Authority, released an RFI asking Apple what it is implementing according to the obligations of the DMA. Like, that is the question. It's like, what are you doing to implement the DMA in Europe? Could you let me know about that? And the interesting thing is, like, this case, and like full disclosure, I'm one of the lawyers in the case, so like I'm only trying to bring up the discussion because I think it really matters here. But there's a pending analysis of a preventive measure. So to me, I look at that and I say, okay, the authority is clearly trying to see if there's something that the company is already doing elsewhere that it could say, like, okay, because you're already doing that there, just do the same thing here and, we'll solve the problem. This is one example, of course, but I think there are two facets of this that I would like your views on, which are like case specific. So this is case specific. It's one case, it's being discussed, what are the remedies, etc. But that could also happen like market-wide, right? So there's a big question about whether the companies will indeed try to some extent to apply the obligations of the DMA across the board. That makes sense. It will only happen to some of the obligations and not to others. And how do you feel like that could potentially like impact the legislative efforts that are being taken elsewhere, which is also the case of Brazil? We have a pending bill of law. There is, as Ricardo was saying, an ongoing discussion at the Ministry of Finance. CAGI has started being very active very recently on saying very explicitly that it understands that ex-ante measures are needed, and that they should be placed at the head of the antitrust authority. So I'm not sure how your view is on that. Also, coming from the UK might be an interesting perspective of like how that is playing out.
Shall I?
Please do address
Interesting
spillover
advice. Interesting advice from CAGI. You raise a question that I think is a very logical one, and I'm trying to myself if I were in one of the big tech, and they were asking me what shall we do. My expectation would be that the big tech would not entirely like to extend an obligation they have to take, let's say for EU or for UK, anywhere else. Why would they? They would do it under two conditions, or if two factors are at place. One, extending it to all over the world or to other jurisdictions does not cost them money or make them lose any extra profits. And B, if you then have to choose where do I extend it to, it would be to jurisdictions that I'm concerned they may come back at me with a similar type of investigation. So I might as well do it preemptively, because I know if I don't do it preemptively, they will push the button to start.
Or with similar legislation, right? Which would be even worse, because then you have no room to argue.
Exactly. So if there's a jurisdiction in the world that does not have a DMA type law, and I'm not really concerned as a big tech that competition authority is ever going to bother with me because of the context, I would not necessarily rush change my behavior there. If I can make it technically, and from a product point of view, I can make the change throughout the globe, it's also a good selling point for all of competitions. Look at me, I'm actually not just correcting the issue in the EU, I'm playing so hardball with all of you, I'm doing it across the globe. I don't think that's how the big tech, from a corporate perspective, would actually see it though. Let's try to do it everywhere. I think they will try to play a game of, where shall I do it that I don't lose money, and at the same time, I don't have a DMA type thing haunting me.
Agree.
I'll just pass the floor to Suva, but another thing that I think is going to play a role here is your friend's perception and the discussions on whether the changes are positive or negative, and the perception of the other authorities, right, and consumers elsewhere, whether that's better or worse. Like recently, I heard the same type of complaint or discussion that you mentioned your friend on Maps about Google Flights from an American that went to the EU and said, look, I'm used to go to Google and go directly to Google Flights, and now in the EU I can't do that anymore, and that's a pain, so on and so forth. So there is, I think, different perceptions on what's going to be the impact, and the impact of competition as well, not only in consumer experience, but in competition, on whether that's really going to change the environment of competition. I think that's an additional layer in this conversation, which I find extremely interesting as well.
Can I just reflect? I think a counter argument to both our friends would be that we are used to a status quo that was imposed on us through a particular behavior. The fact that we do not like the change is because we are used to the status quo. What we do not know is the counterfactual. What would we be able to have if innovation, let's say, was able to flourish if big tech company were not adopting a similar behavior that has led to the product in the first place. So it's really interesting discussion.
Sure. And I think if it flourishes like new map services or new flight services, then in Europe, for instance, there's going to be an important issue for the other authorities to say, look, this probably is something that is positive, right? So looking at the experience of different jurisdictions, you may have different perspectives on what works, what doesn't, what's best, what's not, right? But please, I'd like to pass on the floor to Sylvia as well.
And Professor for the great lecture about the regulatory framework. One of the important things that you mentioned, and I think it should be very relevant for the Brazilian scenario, is the fact that the DMA is very detailed. So the DMA is very detailed and very specific. So actually, the powers were given to the regulator to decide how to regulate the market. So the regulators has, let's say, less power to decide. They have no discretion in doing that. They're going to enforce the DMA. And I understand that the DMCC actually has the opposite approach, in the sense that rather it's more generic, giving the regulators power to decide what to do with the regulation. I wonder which model would fit better. I don't want you to give any thoughts on that unless you want, but and maybe Brazil have still are really seeing what's going to happen in Europe and decide precisely to do what to do in Brazil. CADE has already stated that they want to have, they believe that we should have excess regulation. They believe that CADE should be part of the regulator process. The process is probably regulating the market itself. But they haven't said anything about the design, the institutional framework of this regulation, because I believe that they are still waiting to see what's happening in Europe. So I do believe that the DMA experience and also the UK experience are going to be very important for us to decide. So bearing all of this in mind, and considering what Marcel and Kyle just said, what metrics and criteria do it's important for us to look and to check which model seems to be more suitable or more efficient. Of course, it will depend on Brazilian reality, but how to measure if DMA is being efficient? Because one of the main topics that the DMA has very present is the fairness concept, as you mentioned. But Brazil, the fairness concept is not related at all with the trust enforcement in Brazil. So we do not have that. I'm not so sure if this is going to be adopted here, but it will be very challenging for us to use it. But what kind of criteria or KPIs we should look to decide whether one regime or other regime is doing what it should do?
I think enforcement track record is definitely a part of it. We need to allow the Commission time to show how it will apply it. So we need to have Commission time to bring in cases to conclusion. That conclusion may be a penalty or may be the commitment, but we get conclusion of this investigation. And because that is going to give us an indication of whether DMA ticks the boxes the Commission wanted to do when it comes to expediency and accuracy of enforcement. Impact on the market will take a bit more time to assess. We have seen, at least in the EU, some initial indicators, but it will take more time to assess it. The ultimate aim of DMA, which would be, let's bring in new companies, what Kai was saying, to do a better map service, that will take time to be able to look to see whether this has happened. It will not be an issue of 1 or 2 years. And I don't think any authority will wait for that KPI to materialize before they decide how to proceed. For any country or Brazil, I think it's a good thing that they wait to see how DMA will apply, because you already have somebody who's doing it already who is, I would safely guess, better resourced than CAGE. So let's see how they do it. Let's see whether they can be as CAGE, can CAGE piggyback on the DMA commitments on any company. So what you were mentioning, because then what's the point of reinventing the whole week and the whole week? Because then you will have the companies understandably saying, I have commitment A here, commitment B there, commitment C over there. Can you all authorities talk to each other to at least come up with a commitment across the board because it's one service across the board? So I think CAGE is good that it's waiting to see how it's going to be applied. I'm sure they're talking to each company anyway, so they know how they do it. Metrics, I think we need some time. I wish, and I know we would all be eager to be able to kind of have the results and be able to assess. We've been talking about the DMA for the last 4 years, 5 years now, and we still have not seen anything tangible coming out of it. But we need to wait a bit more to see success of the cases, how soon the commitments change the behavior of the companies.
I totally understand that we need more time to see the results, but I'm also not trying to it should be followed and then try to pursue to check if it's the result that you are.
Yeah. And I think the other side of the coin is, so what Kaji said in his contribution regarding like the discussion on whether or not ex-ante regulation should be applicable was that, Brazil shouldn't copy paste whatever exists elsewhere. That's dangerous. It has issues with like human resources, capacity for enforcement, etc. But if it were to implement something, it should focus on like real Brazilian issues, right? So the local issues that we have here that are probably to at least, some extent different from the issue that you have in Europe. And I think maybe the question that I would have for them now, and I'm not sure like if the European or the UK experiences provide an insight into that, is like, okay, so how do you assess those Brazilian issues, right? So unlike other jurisdictions, we didn't have like a Berman report or, a Stiegler Center report or European Commission report, etc. So one could say that maybe that's the way to go. Do a comprehensive market study of everything platform in Brazil, come up, take 2 years to do it, come up with the results, and then you, implement whatever makes sense. But my feeling is that the authority would probably think that's too long, or most of those reports have been done already and we should try to do something else. But I look at it and I say, okay, what something else would that be? I mean, nobody has done anything particularly different. Maybe the UK has done it through market investigations, but then again, that's already a kind of investigation. So I'm not sure if the international experience helps us a lot in that discussion. I'm not sure particularly.
I don't think if CAGE does a report like that, I don't think they'll come up with any different findings to any other part of the world, because these are global digital markets. But if we compare the reports and the actual text of DMA, they're not very similar. The conduct of DMA are some which are very, very specific. In my personal view, they materialized after lengthy discussions of the Commission with complainants, because some of these conducts there are really detailed and narrow. So maybe CAGE can, maybe it's doing it already, liaise with complainants in Brazil on what issues they see in the Brazilian context, and I don't know if you have Brazilian gatekeepers, which are not the usual ones, the big ones.
Maybe the markets,
So if they can identify specific conducts that are relevant for Brazil, you may have a DMA type regulation, which will have very narrow prescriptive conducts there, which will be as a result of this type of discussions. Because I don't think the Commission cannot have come up with this type of conduct out of its own head. It's too technical. So some of these conducts we see now in complaints already. That could be something that CAGE could do, for example, without the report, because they take too long and it will not come up with anything different.
Super interesting. Just before we open the floor, I'd like to hear a little bit more on two of the tools. One that you mentioned, and I think one that you didn't mention yet, but one is the pro-competition intervention. I think that's probably one of the biggest innovations of the DMCC, in the sense that it's providing CMA with a tool that doesn't require any type of like specific conduct, but could be a market-wide intervention. As far as I understand, it's like data portability or interoperability or things like that, right? So my question is, CMA has had the power of market studies for a while, and used very seldom, right? I mean, the BAA case is probably the most important example that we have. And my question is, will they use that more often, do you think? And to what extent it's going to lead to big challenges in judicial review as well? So that's one tool that I think is particularly interesting to look at. But the other one that I heard comments and criticisms about is the final offer tool that, as far as I understand, is that you have a remedy on access, for instance, and the parties can't reach an agreement on the pricing or the conditions of access. Both of the parties need to present their final offers to the CMA, and the CMA is going to choose one of the final offers, right? So I think the idea is that they would present reasonable offers because they don't want to be far off from what the CMA would choose. Some would say that this is very interventionist. Some would say this is an interesting tool to test. I'd like to hear a bit of your views on that as well.
Let me take the market investigation one. CMA has done market investigations in different markets, including digital. So now they're doing the cloud, for example, cloud market. And the difference between these investigations and this tool is that the investigations under the Competition Act and through the Enterprise Act, they are very lengthy, very detailed, very voluminous investigations. Here, the aim is they will look at the market, they will identify a set of structural issues that they will need to address without having to go through the same depth of analysis and length. For the same reason, you want to have a fast enforcement. Now, whether, and this question is, after a quick and dirty market investigation under the DMCC, will the outcome be appropriate? I would hope CMA will not take these investigations lightly, and that when they actually do an investigation on the DMCC, they will do it they will be confident with the way they will do it, they will get an appropriate outcome, an accurate outcome. Because otherwise, if it takes you 3 years to investigate the market and you will do it now in a few months, there's something which is at odds there. So you need, as CMA, you need to make sure your intervention in the 3 months or 6 months or a year process is going to be accurate. It's interesting. It's an interesting approach CMA takes. It has a long experience in market investigations, much longer than any other European country and European agency. It may or may not use it, but I think it's one that it will use when it feels appropriate to do so. So I don't expect CMA will actually fall foul of its own benefit of having the ability to actually go and use this type of tool. But we'll see. It's an interesting question how it will actually enforce it. On the final offer, it's an interesting change of what we have so far, because we don't have it, for example. You can say we have it slightly in remedies in mergers. It's kind of take it or leave it. You offer the remedy, doesn't work out, you're blocked. I guess my own reading of this is CMA is trying to avoid having to become the arbitrator of two very complicated, different proposals that they have to bring in experts to assess them, to decide for themselves. So they try to get the parties to come to a common understanding of some type and present it to CMA. DMA doesn't have that. So it's an interesting one, how CMA will actually, why CMA is doing it. My own view is because it feels it does not want to be the arbitrator on very highly complex technical matters that the DMCC will actually cover.
yeah, it's going to be interesting to see, because it's really a laboratory, right? We're seeing many different tools being tested in different jurisdictions.
Yes, exactly.
So that's what we're seeing at this point. But let me also open for questions and comments from the audience, of course, with the possibility of our commentators here also to interact and to comment further, but so that we do have quite a few people that are very knowledgeable in competition law here as well. So any questions, comments? I mean, we certainly have lots more here, but I'd like to open for.
One thing that I was wondering also about the measures, does it have like a threshold, like an interim measure so that the CMA may impose it? Is it more likely? How is it?
CMA has interim measures, can actually impose interim measures.
I was wondering the difference there.
Part of what it can do under the market investigation will be to actually be able to step in and put in place interim measures if it thinks that there is significant harm at place, which is imminent. But it can use interim measures under its standard competition rules as well. It doesn't need to have it explicitly in the DMCC in order to be able to do that. And it has done it on many occasions.
Yeah, so I was wondering which is the difference, like, because the interim measure would be in a specific case, and this one would be for the market.
Yes. So in the measure you assess the conduct of a company, and then you put the measure on the company. Here is you assess the market. There's an issue. You need to come in to step in to address it immediately. It's in comparison.
So I have a specific question about, you mentioned the DMCC changes merger notification thresholds to catch potentially blurred positions. And I was wondering what kind of nexus requirements is there for the startup firm to be in the UK or under the jurisdiction of the CMA? Because deal acquisitions, usually firms are small. They will have a huge impact in the UK when they become big, but they might be based in Silicon Valley or wherever else. And what kind of test is required to catch them, and your views on this? So
the DMCC changes the threshold, but applies the same rationale notification for the transaction for the nexus. So UK has one of the easiest notification approaches. Oh, sorry, let me rephrase this. Has one of the easiest jurisdiction approaches, because in the UK, the thresholds, you have the monetary threshold, so the 10 million that we show here, for example, but then you have what is called the share of supply, which is also changed with the DMCC, which is if wherever the startup is based, as long as it has the potential impact in the UK market, that can suffice to bring it under its jurisdiction. So an example that lawyers, friends of mine are telling me when I ask them what is the worst case they have seen, is they tell me they saw a case involving chocolates. And the CMA years ago called in a chocolate merger, not based on the turnover threshold, because it was not meeting the turnover threshold, based on the share of supply of a specific type of chocolate in the UK. So this is not a market definition, this is not market share. So the CMA called it in based on the fact, for example, that the companies would have more than 25% of 70% dark chocolate in UK, which is not a market though. So UK has a very lax notification jurisdictional arm. They will apply the same one here, they will just have lower threshold. So whether the startup is in Silicon Valley, as long as it produces, it has a service which affects UK customers potentially or actually, that would suffice.
Do you think this would be easy to enforce? I mean, is this?
Yeah.
You
make sure of that.
That's a very interesting and complicated case. That's a case that the CMA thinks it won. Parties think they won. No, they cannot both have won. Somebody must have lost something there. So, but back to vision though, there's a market in the UK for first shooter gaming. The issue there goes with remedies and whether CMA and the UK regime is having behavioral remedies, and it's clear it's not. EU is different in that respect. But we don't have a CMA case of this type, but we have now EU going to an extreme. I don't know if you have followed the Lumina Gray, for example, that EU called in a transaction and blocked it with the target not being active in Europe yet. And we'll see now, because it's already in Court of Justice, they may reverse it, we'll see. But the way measure control is going, I don't think any authority, at least UK or EC, will have any problem in bringing in difficult cases.
Go ahead, Ricardo. Ricardo is Director of Digital Markets at IBRAC as well. So very good to have you here. Thank you.
Oh, yeah, and thank you, Professor, for the great lecture. My question, I'd like to go back to the consumer efficient point. And Kyle brought the point of Google Flights, where consumers would be like embarrassed or somehow confused of how dealing in Europe, United States, and some of them would prefer one or the other. And I understand that. I understood that the efficiency under the DMA, the DMCA, it is restricted to consumer efficiencies. But there's another part, because Kyle mentioned Google Flights, and there's also Google Hotels, or there are Google Shopping, for example, where you have merchants or you have hotels, and you have some claims being brought by these actors in the environment, saying that now they need to deal with different platforms or different intermediaries, and they cannot reach directly consumers because now Google, for example, needs to show all of them in the same way, all the competitors or the intermediaries in the same way, so it cannot link directly users to these merchants and for that. How the digital unit in UK will consider these claims that they're not consumers in the sense of a restricted definition of consumers, but they are end users as well. They're in the different side of platforms. What they will do with these claims, they will be considered, not considered, how they will deal with these different points coming in a specific case.
Judging from the history of how the CMA enforces or takes into account the concept of consumer and end user, in the past they have considered it to be equivalent. So I would not think that they will have a problem there because it's consumer. If it's an end user, for the CMA to say it's an end user, it's not a consumer. Because if they do so, A, it's different to the past approach, not in digital markets, in other kind of markets. B, it goes against some of the point of having a new legislation coming in to be able to address some of these behaviors that affect another stakeholder. A counterparty, let's call it the counterparty. So it would be surprising. We'll see. But I would think that they will actually equate end user and consumer in that respect.
Can I have just one more third? Now, okay, that's fair, and that's a very interesting approach because you consider all the efficiencies. What's that far from the model that we have today, where we consider both sides of the platform? How we differentiate, and how? I understand, okay, the standard is not that far, not that high, but not that low, but how are gonna those, in fact, the standard to say, okay, it's stricter or not?
It's not the reason the threshold is lower in the DMC is not the use of the consumer versus end user, or the use of the consumer as a word. It's the fact that the DMCC says about necessity, that it's not it has to show, the CMA has to show that these benefits the CMA has to be convinced that these benefits would not have arisen without that conduct. So the conduct is necessary for the benefits to arise. So it's the wording of how the company will prove the necessity of the benefits which makes it a lower threshold. It's not a consumer use or versus end users, for example.
So to the burden of proof in this sense.
Yeah. Yes, it's similar. This discussion now brings back in memory the change from BA, from Michelin to BA on it is for competitive conduct 1 or 2, it is enough to be shown that it is likely to have a competitive impact. So it kind of lowers the threshold of proof in a way.
Thank you.
If I may, there's one issue that you mentioned the current investigations that the European Commission has started on some of the gatekeepers. And you mentioned matters, which is focused on mostly the pay and consent model. And I'd like your view on one aspect that I feel is where the European Commission and the European Union in general is going towards that issue, which I'm not sure is shared by other people, but I find particularly interesting to discuss, which is, to me, it feels like what the European Union is doing is just putting the business model of online behavioral advertising in a corner and just kind of like shooting at it from every possible angle and just basically saying, we don't want this. Just find some other way to make money. We hate it. So we're not blatantly saying that we want to, make it unlawful for there to be online behavioral advertising. And I mean, we could discuss why that is. Like, it's generally bad to say that you don't want a specific business model, but they're shooting at it from like every single direction, right? Like the GDPR provisions, the investigations focus on that, the DMA, the DSA itself, like several of them.
German Facebook case.
The German Facebook, like everything. You look at the cases and you say, okay, so what they're trying, at least in my view, what they're trying to do is just say, find a different business model. And my question is, like, in the general context of the DMA, to a certain extent, and that relates to what Ricardo was saying as well, it feels like what the Commission wants at the end of the day is to establish, like, incentive for new business models that they feel would be good for innovation, would, bring about new things, but also sometimes that are not necessarily just innovative. It's just like, we want this kind of market structure. We want another kind of market structure. And I mean, I think that is all fine, so long as everyone is aware of what is happening. And I think that some of the discussions that are happening in other jurisdictions to adopt some of the ex-ante rules, like the DMA, don't necessarily have this full picture in mind of like what the final aim of what they're doing is in the whole context. And my feeling is that the UK knows this, for example, and that is one of the reasons why it also wants to implement a slightly different model, because perhaps that is one of the things that they're trying to avoid. Like, okay, I mean, we think there's more room for, free market in a way, and we value this a little bit more, perhaps. But I'm not sure this is shared, especially like when I talk to European scholars. There's some people that say, oh, for sure, that is what's going on. And usually people that, are lawyers tend to agree with my view, and those that are not don't necessarily. So I was curious about what your view is on this, like, more geopolitical movement that the Commission is, in my mind, trying to do.
Two comments. One on, you mentioned GDPR.
Yeah.
And you're right, GDPR does the same thing that DMA does when it comes to.
Yeah.
But nobody was complaining with GDPR. So why nobody was complaining? Oh, not as many strong complaints were there when the GDPR came in, which One reading is because the penalties were not really effective for GDPR, so companies could maintain the business model without really caring that much. Now you have a model, you have a tool, regulation, which can bite, so then you have more reaction. I see your point, I see that point, but if we go back and we look at one or two cases, I don't know if it's in every single one or two cases, in most one or two cases, there has been a change in the business model of what the company was doing. So you used to commercial solvents. You cannot now not supply your downstream competitor, your downstream now competitor. So most one or two cases have brought about a change in the business model. The Google search case brought a change in the business model, but it, in my view, from what I understand, I don't think now the boxes we see on Google, the results on Google have had any significant impact on Google's shopping revenue, because they still, so you still have a legitimate approach. And I think it's a balanced approach. The Commission said, look, you just need to make it fair. If you're still the one to be chosen, that's consumers' reaction. But you need to give that option to be fair. So I see what you're saying. You have to, DMA is important, you have to change the business model, find another way, and you cannot make money anymore from advertising. This, I'm sure, would have been the same issue in every single big one or two case in the last 40 years. I think it's now for the parties to come up with that new approach would be that they will maximize the remaining profits they can have.
Yeah,
And you don't know, maybe consumers will not switch, will not change. So then,
yeah, and it's interesting because like the alternative that they're providing at the moment, which is like, okay, so we need another way to make money, then pay us directly and we will, swipe the ads off. It's just like the Commission is saying, oh, we also don't want that. So I look at it and I say, okay, maybe the most interesting place to work today, like business development at Meta, because you're like, okay, I have to change the whole way that my company functions and how it makes money because of that.
in the UK, we have had a number of regulators coming for this consumer inertia. So over 10 years ago, as a result of a market investigation by Ofgem, we started receiving emails from our existing electricity supplier with new, cheaper offers of competitors to the one we have. That's a massive change. So the company has to let its customers know my competitor is cheaper than what I offer you. If we look at what happened, market share didn't change much because people still stuck to what they're used to. But if that was intrusive then, so I cannot see why the authorities will not be happy to introduce another intrusive measure like the one you described.
Very interesting exchange here. Any other questions, please?
So Professor, thank you for your presentation. It's very insightful and informative. I would like to make a specific question about the matter of the countervailing event, right? That's because from what I gather, this is not a possibility under the DMA, which often violates the rules that you can't make by countervailing events, but it is a possibility under the DMCC, right? And that takes me off maybe to the matter of different goals of regulation between these two jurisdictions, because as we know, the DMA has stated goals which are pretty related to fairness and contestability. And I wonder if in the context of the DMA, this countervailing benefits offense wasn't included because of these goals, because, well, if the goal of the regulation is mostly to preserve fairness, competition, and contestability, it doesn't really matter, or it doesn't matter much if there are countervailing benefits to consumers, because they have their abilities to be hampered anyway. So I wonder if you could expand a bit on these differences, the possibility of
maybe part of it benefits defense under the true regulations, and then your views on if this is related to different goals. Maybe the DMA is more concerned with fairness and contestability, while the DMCC preserves a little bit more concern with this out there. So your views on that?
DMA, if you take Article 5 of DMA, the conduct there, these are conducts which we could argue are equivalent to the traditional hardcore infringement of the cartel case. So you've done these conducts. Article 6 does provide not a lot of them, companies to come to go and argue why these conducts are necessary. And part of it could be because they have efficiency. There is an underlying efficiency type argumentation that they can put in. In previous versions of DMA, I don't know if it's still there. I think it's still there. The efficiency clause was there explicitly. But Article 6 does give companies all the conducts in Article 6. Companies can go and argue, I still need to do it for this and that. So there's enough room there. Article 5, I take the point. There's some conducts there. And if you look at Article 5, some of the conducts are unnecessary. Okay, what I say. There's a conduct there which says the company cannot prevent the customers or stakeholders, the users from going to courts. It's a weird conduct to have in regulation, for example. So the meeting conducts, the GDPR type conduct, the 5A, there's a GDPR exception. So again, there is an exception there. So take Article 5, remove, if you stick to the conduct which are the really problematic ones, and you compare with what would be a hardcore type approach, is the same type of approach, which we don't really have in defense in the hardcore case. And I think efficiency is still, I can't remember the article, I think it's still mentioned as a potential argument that can be brought forward in DMA. I need to find the article though, where is it at? On the consumer welfare approach, EC has always been arguing it takes a consumer welfare approach. I wouldn't argue myself. I would say DMA is EC also saying I'm taking a consumer welfare approach fully here, which is similar to what the UK is doing. They're using different terms, different concepts to determine what exactly they mean by consumer welfare and where it applies. But I wouldn't say that the underlying aim of both regulations is different. They have differences in the tools they apply, but I wouldn't say it's different. I would say the underlying aim is the same.
Maybe what shifts when you shift to contestability is like this more dynamic and long-term view about the impacts in the market instead of like this more static and short-term view that we're used to in competition law, right? So that's an issue. But I think it's going to be very interesting to see how efficiency defense play in the UK. And also, I believe that the 19A in Germany also allows for efficiency defenses as well. So how the companies are going to present and how they're going to be accepted in both regimes, I think is going to be quite interesting to follow.
I think EC will be pragmatic, Article 6 justifications by the companies. I think EC has had commission over the years in different areas of law. They have introduced a lot of tools that they could have applied really strictly, and in my view, they have applied them in a rational way. So I think if a company goes and presents a set of facts why it's necessary, I don't think EC would just close its eyes and say, no, dogmatically, it's wrong. I think I know it's scary for everybody, all of us, because it's new, but the balance, I think EC will find the balance that it needs to be found in these markets.
Yeah, in Article 6, it says more room for the balance, right? Yeah, that's true. So we're coming close to an end of our conversation here as we're start to compete with lunch and other interests of people as well. But I'd like to give a final opportunity for any other question or comment that anybody would like to make.
Any additional questions? I'll have a final one. You mentioned the presentation that initial view of the results of it seems that the company is the bottom points and gatekeeper thing to be testing the DMA, the limits of the DMA, especially because the DMA is focused on the core business nowadays, so they have incentives to fight and to gain. But how do you think that the DMCC is going to avoid this kind of problem, especially because it's broader?
Yes. I did say there, and I believe that the companies are testing the limits. Not all companies. I will not name companies. We know which companies we're talking about. Some companies have been more forthcoming. Some companies have been less forthcoming. Some companies have fought even the gatekeeper designation. Some of them have not. So the companies have taken different approaches. But I wouldn't expect it. If I were, I would say, let's push as much as we can. We will come up to a new balance, a new equilibrium, which will not be what we want, but may not be what it will be if we just drop our weapons down and just accept everything. EC, we need to make a judgment here on what is that balance. But I think companies are playing a game that I would expect them to play, to be honest. And because I've only slept 6 hours in 72 hours, I'm going to your second question. My short memory doesn't work well.
Yeah.
What was your second question?
No, the second question was that how the DMCC is going to be able to avoid.
Yes.
I understand that being more flexible, they are going to be flexible to adapt to the restrictions or the provisions according to the business model of each platform. So, but I don't know if it's only this approach or there's something else that's going to be helpful for the to avoid this kind of result.
The one benefit DMCC has, practical benefit, is time. Because by the time it comes into force, there will already be, and of course, the digital company and CMA are talking, there will be, or there should be, there will be some understanding of some lessons for some of these approaches. If I compare the approach of CMA and EC to digital markets, generally speaking, I wouldn't say CMA is more lenient than EC. I would say CMA is stricter than EC so far. Let's post-Brexit, unilateral conduct cases, bank investigations, market acquisition. I would say that CMA has shown a less strict phase than EC. I would say EC has shown less strict phase than CMA. So I don't think the companies would have a lot of room to maneuver before CMA, before DMCC. I think DMCC may even be stricter. So CMA under DMCC may be stricter than EC can be. So
they have already their approach.
If you ask me what is my view on the CMA's approach to digital markets compared to EC, is stricter.
Because one of the issues that I was thinking about regulation that Europe gatekeepers are testing the limits, is that they may keep discussing exposed remedies, and the whole goal of having exempt remedies is to avoid to discuss exposed remedies, because one of the justifications to have the exempt regulation is because remedies was showing not to be very efficient indeed. So if you're keeping only discuss exposed remedies, I understand that for a period of time for the gatekeeper to comply with the new rule, of course they'll have to adjust their strategies, and then we are discussing exposed remedies. But if they keep doing that as an enforcement on a regular basis to enforce all the time the DMA, then you're back to the scenario that had before.
The whole point is not to have to take in remedies exposed.
Yeah. That's it.
but it depends on the company.
Of course, of course.
And if they do have to take exposed, we would wish there would be quicker processes than fast.
Thank you very much. Marcela, Ricardo, would like to, any final comments?
No, just to thank everyone again for.
Well, thank you. It was a pleasure to hear from Ioannis and all of the very rich discussion that followed. Thank you very much for the invitation, for the organization, for making this happen. It's a pleasure.
My pleasure. Thank you, Ioannis, again for coming and speaking again here at FGV. Please do always let us know when you are coming through the country, because we would like to keep this conversation. I think this is a conversation that's just starting. I think many jurisdictions are taking different paths. As I mentioned, we're currently moving from a stage where I think all authorities were discussing like best practices to a stage where all authorities are discussing different approaches and learning from different approaches. So I think it's a much different role than we had 15 years ago, and we need to watch it closely, have more conversations, and learn more about the different approaches here. So thank you so much for bringing this discussion to us as well. And thank you all for coming. This was short notice event, and it's great to have this conversation with people that are very enthusiastic about the subject and very knowledgeable about it. So thank you for coming again.